Welcome to the Law in Context podcast.
I'm Emeritus Professor Stephen Bottomley, former Dean of Law at the Australian National University in Canberra.
And I'm Emeritus Professor Stephen Parker, former Dean of Law at Monash University in Melbourne.
Between us, we have written books and articles on corporations law, lawyers' ethics, family law and many other legal topics.
In most episodes, we take a legal topic of interest, perhaps one that's in the news, and relate it back to fundamental questions about the legal system.
So whether you are a member of the public wanting to know more about law and make sense of what is in the news, or you are studying legal studies, criminology, or even a law degree, our plan is to help you with a deeper understanding of what is going on.
Juries make for great books and movies. We'll find out what their role really is in the adversarial system in this episode devoted to the jury.
Let's start with the word jury. What does it mean?
The word derives from the Latin verb jurare, meaning to swear. Today's wording generally involves a juror swearing to faithfully and impartially try the issues and deliver a true verdict according to the evidence.
How did juries come about?
Juries developed in England during the Middle Ages. In fact, the Magna Carta in 1215 proclaimed the right to be tried by one's peers. They are a hallmark of common law jurisdictions, but are not generally used in other types of legal system, such as the inquisitorial ones in Europe or Islamic Sharia law.
We're used to thinking that juries have 12 members, perhaps because we've all seen films like 12 Angry Men. But is it always 12?
Yes, normally. Trial juries are petit juries, meaning small juries, and do usually consist of 12 people in criminal cases. Historically, a larger jury, known as a grand jury, was used to investigate potential crimes and bring indictments against suspects, whilst smaller juries were part of the process of actually trying them. All common law jurisdictions have phased out grand juries, except about half the states in the USA, but the petit jury is a standard feature everywhere in the more serious types of offences.
Section 80 of the Australian Constitution provides that the trial on indictment of any offence against any law of the Commonwealth shall be by jury. All other jurisdictions in Australia give defendants the right to a jury trial for serious offences, although they can agree to be tried by a judge alone.
We have emphasised criminal matters here, but jury trials using smaller juries of between 4 and 8 are still possible in civil matters. This is relatively rare, but you do see them in defamation and personal injuries cases.
Juries decide questions of fact, including the fact of whether the case has been made out to the required standard of proof. However, it is up to the judge to decide questions of law.
And once the verdict is delivered, it's the judge who decides the sentence, not the jury.
We said earlier that juries are a feature of common law systems and that by and large other legal systems don't have them. Why is this?
It stems from the particular fear in common law countries of the state misusing its power to prosecute and judges having too large a role in deciding people's fate. When I went to law school in England, the first essay I had to write was on the jury as a bulwark against tyranny. I'm not sure any of us 18-year-olds really knew what a bulwark was, but if it prevented tyranny, it had to be a good thing.
Juries are intended to bring a common sense element into trials, as well as local knowledge. It's possible they are also a safety valve against prosecutions that were strictly correct, but really should not have been brought.
There's a joke, possibly fictional, of a jury in a country area where everyone knew everyone else in the case, delivering a verdict of not guilty but don't do it again.
That's as feeble as most of your jokes.
As you can imagine, there are numerous rules about juries and their deliberations, which we can't cover in full. But there are some key facts that, if our listeners are still awake, may be of interest.
Juries are randomly selected from those over the age of 18 on the electoral roll. They must serve unless ineligible. For example, lawyers, police, and judges, or excused on certain grounds or successfully challenged. Jury service is one of the two kinds of mandatory civic participation in Australia, along with compulsory voting in elections.
The defence can challenge up to 3 jurors without cause, based on what the defence thinks by looking at them, the so-called peremptory challenge, and unlimited challenges for cause.
It is an offence for a juror to make their own inquiries. In a high-profile case of a so-called detective juror in Canberra recently, a prosecution was abandoned because the juror conducted his own research into an issue and shared it with the others. This was after the judge had given at least 17 warnings against doing this. The prohibition on separate inquiry means no web searching, consulting other people, conducting experiments or inspecting a place or object. This is because the jury's decision must be based solely on the permissible evidence that is presented to the court.
Once the jury has retired to deliberate, they must not have access to their mobile phones, nor, usually, should they separate, but if they are allowed to do so by the judge, they swear an oath not to discuss the case with anyone.
The judge can allow a majority verdict if the jury has deliberated for a period of time the judge thinks reasonable. In the normal case of 12 jurors, then 11 must agree to the verdict. Majority verdicts are not available with some offences, such as murder, nor offences under Commonwealth law.
Once delivered, the judge has to accept the verdict, but in extremely rare cases may direct the jury to reconsider.
There are some surprising grey areas. Surprising because the institution of the jury itself is so old.
Jurors can take notes, but some judges don't like it and warn them that the demeanour of witnesses is important, so they should not be distracted by note-taking. I'm not sure how many jurors will take notes knowing that the judge disapproves.
Jurors have the right to question witnesses, but bizarrely, they should not be told of this right. However, if somehow they make their wish known, they can ask questions to clarify evidence or seek an explanation where there is confusion.
In the same way that grand juries have almost disappeared, it's reasonable to ask whether the smaller jury of 12 people has also had its day.
Trials can go for many weeks. Is it reasonable to ask people to give up that much time? And if some jurors are excused because of the predicted length of the trial, we are left only with jurors who presumably do have time on their hands.
Trials can also be incredibly complex, such as in corporate fraud. Does any ordinary juror really understand what is going on?
Also, the population today is different. We have more diversity of language and background. We have a generation used to screens and social media and perhaps not used to sitting still for several days just listening to words.
The real nub of the issue is whether juries make the right decision. For what it's worth, in limited experiments, juries usually make the same decision that the judge would have done.
However, we cannot know what their reasoning process really was. Because deliberations are confidential for all time, at least in this country, it is difficult to know the typical dynamics of a jury room, including whether some people suppress their reservations because of more dominant characters present.
Nor can we know whether jurors are influenced by widespread, unregulated social media commentary.
In an era of populism, greater inequality and identity politics, can we really be sure that jurors will faithfully and impartially try the issues and give a true verdict according to the evidence?
And at a practical level, jury trials take longer than judge-only trials, and there is a backlog in many court systems, leading to delays that are unfair on defendants. Recently in the UK, the Chief Justice has raised the possibility of limiting the right to jury trial precisely because of the backlog there.
Like many issues in the legal system, one question always has to be, what is the alternative? If you can't find a better one, you stick with what you've got.
Maybe jurors are biased, but there are 12 biases present with the chance of being detected and cancelled out, compared with a single judge deciding on the facts according to their possible biases.
We keep coming back to liberty. It is inconceivable that a dictator would allow a jury system, which may be a very good argument for keeping it.
Let's leave the last word to the singer Paul Simon. I would not be convicted by a jury of my peers, still crazy after all these years. Thank you for listening to this episode. You can find more episodes in this gripping series at lawincontext.com.au or wherever you get your podcasts.
Over time, we will build up resources on the website with further exciting reading on the topics we've discussed.
We're the two Steves, and that was a Law in Context podcast.
And as the two Ronnies used to say,
it's goodbye from me.
And it's goodbye from him.
Bye.
So what do you think?
About limiting jury trials or Paul Simon?
Both.
Well, limiting jury trials is a load of bullwalks. Paul Simon's great.